Hello friends, in this and the next few videos, I will be sharing with you how to argue a writ petition before the High Court. Friends, whatever I am sharing here is based on my long experience as a practicing advocate before the High Court here at Nagpur bench of Bombay High Court. I guess whatever I'll be sharing here will apply more or less to the practice in other high courts also. If you are practicing before any other high court in India, please check at your local place if the practice is similar or if there are any changes, and if yes, which. Okay, so before we proceed, you need to understand the kinds of hearings before the High Court. Now, please watch this video with rapt attention as I would be sharing very important things. While watching, if you think that you lost the track of what I said, you may rewind the video and again watch it. So before you understand how to argue a petition before the High Court, you need to understand what are the nature of hearings that take place before the High Court. See, when you argue a writ petition before the High Court, generally the hearings are of two types. The first type of hearing is the argument at the admission hearing stage. And the second type of hearing is the argument at the final hearing stage. The difference between the two is that, as I have explained in my other videos, admission stage is that stage where the court screens the matter to assess whether the case has any merits or it has any arguable point, so that if the court finds that the case is worthless without any merits, the case can be dismissed then and there itself. But if the court thinks that the case has some merits and worth, then it can be admitted for final hearing. The purpose of admission hearing stage is that the court's dockets should not get piled up with unworthy cases, consuming court's time, which can be utilized for hearing other worthy cases. So, what possible consequences can happen at the admission hearing stage? Number one, if at the first date of hearing or even at later dates, the court does not find any arguable point in the case at admission hearing stage, the court would dismiss the case at that stage itself, at the threshold. This is called dismissal-in-limine. Number two, if at the first date of hearing or even on any other later date, the court thinks that yes, the matter has some merits worth exploring further, then again two consequences may happen. First, without straightway admitting the matter by issuing rule, but also without dismissing the case, the court would simply issue notices before admission by calling upon the respondents to file its reply on affidavit. In that situation, while issuing notices, the court may, in its order, make it clear to all the parties that the court intends to dispose of the matter finally at the admission stage itself. This means that the court wants to decide the matter quickly without admitting it for final hearing, which may result in coming up the matter for final hearing after many years, which situation is very pathetic. So to avoid delay in disposal of the matter, the courts have come up with this practice of quick disposal of the cases, which is in the interest of people. Please also note that this does not restrain the court of its power to admit the petition for final hearing by issuing rule if during later hearings the court comes to the conclusion that rule should be issued and the petition should be admitted for final hearing. But let me tell you, the chance of this happening is very less because the court has already expressed its intention to dispose of the matter quickly at the admission hearing stage itself. So this may result in the decision either way. Either the court may allow the petition or the court may dismiss the petition. But then this will be as if the court has heard the case for final hearing, though at the admission stage itself. Now you will notice that many times while disposing of the petition finally at the admission stage, the court would at the very beginning of the order mention that the court heard the matter finally with the consent of the parties and that the court issued rule and made it returnable forthwith, means then and there. This means that even at the admission stage, when the case is disposed of finally on merits after hearing it in detail, the court issues a rule and makes it returnable then and there, instantly, without keeping the case pending for years together. And then the court hears the case and disposes it off finally. So technically, the matter is admitted and disposed of finally. The second thing that may happen is that the court would directly admit the case for final hearing by issuing rule nisi. Now, those who do not know what rule nisi is, I have made a separate video on this very topic. So please watch that video. So in this situation, the case would lay waiting for a final detailed hearing for a quite long time in the queue of cases for final hearing. This unfortunately results in keeping the case pending for years together, and the case would come up for final hearing much later. And whenever the case would be taken up for final hearing, it would be heard in greater depth. This hearing is called the final hearing stage. Therefore, because of this difference, the hearing, that means the arguments in both types, are different. So how to argue a case at the admission hearing stage and at the final hearing stage? That we will understand in the next video. Dear friends, I want to leave you with a thought that has guided me throughout my years of practice. Remember, every case you take on is an opportunity to make a positive impact on someone's life. It's a chance to champion justice and uphold the rule of law. In those moments when the legal battle seems arduous, when you face challenges and setbacks, always hold on to your unwavering belief in the power of law. Know that your dedication, your timeless efforts, and your commitment to justice can shape the course of lives of communities. So embrace every opportunity of argument as a chance to refine your skills, to learn and to grow. Never underestimate the value of persistence and the strength that comes from pushing through adversity. And remember, it's not just about winning cases, it's about ensuring that every individual you represent receives fair and just treatment. It's about being a voice for the voiceless, a beacon of hope for those in need. As you step into the legal arena, carry with you the responsibility to uphold the highest standards of integrity and justice. Let your actions speak volumes about your commitment to justice, and let your advocacy be a force for positive change. Never lose sight of the impact you can have. Your work can shape the legal landscape and leave a legacy for generations to come. So stand tall, be fearless, and let your passion for justice be the driving force behind every argument you make. You are the future of the legal profession, and the possibilities are boundless. Embrace them with open arms and steadfast heart. Thank you for joining me on this journey. I have faith in each and every one of you. Go out there and make a difference. The legal world awaits your brilliance. Until next time, keep fighting for what's right. Keep championing justice and never forget the incredible impact you can have. This is Advocate Nahush Khubalkar signing off, and I can't wait to see the incredible advocacy you will bring to the world. Take care and remember, the law is on your side. See you in the next video.